If it pleases the court, my name is Gatt, G-A-T-T, initial B, and I appear today with my senior counsel, Mr. Lynch, for the defendant, the Lighthouse. Your Honour, senior counsel has addressed in detail the initial principle of negligence, action and duty of care, and how this is not applicable to the facts of this case. I will now follow on from statements made by senior counsel to further outline the necessary requirements of negligence in relation to causation, such as scope of liability and remoteness of damage on the defendant's behalf in relation to those facts. When seeking grounds for causation, the court must consider the defendant's scope of liability. Section 11 of the Civil Liability Act requires the court find whether or not there is a distinct connection between the defendant's scope of liability and the harm caused to the plaintiff. Section 12 of the CLA outlines onus of proof rests with the plaintiff to prove that the assumed damage caused is not remote in nature. It must be proven that the damage was reasonably foreseeable in the duty of care owed by the defendant to the plaintiff. The defendant submits to the court that his actions or failure to act did not cause the harm, loss or damage suffered by the plaintiff. Section 5B of the CLA outlines a duty of care is only required where the risk is classed as foreseeable and a significant risk. An insignificant risk does not require a person of reasonable standing to take the appropriate precautions to manage such unforeseeable activity. Packer v. Tall Ship Sailing Cruises Australia, Party Limited, outlines the issue of foreseeability of criminal behaviour in such situations. Defining a foreseeable risk in which a duty of care is owed from one to another is made increasingly difficult by such unpredictable actions which are difficult to be foreseen and planned for. As earlier directed by senior counsel, the Lighthouse is not a licensed establishment. Therefore, the extra costs of providing security guards or such security devices for protection against intoxicated individuals is unwarranted in the scope of liability the Lighthouse owes to its patrons. It would be unreasonable to expect the Lighthouse to have to fork out extra finances for such extreme security measures for risks that are not considered foreseeable for an unlicensed establishment or its customers in daily and general business. It is not foreseeable for the owner of the Lighthouse to expect the intoxicated patron to return to the establishment in a hostile manner after being earlier asked to leave the premises. The ruling in Wagstaff v. Haslam outlines the correct approach for considering causation is by looking at surrounding circumstances and facts to see if on the balance of probabilities the owner could have prevented the assault. It could be argued the defendant even went above their duty of care to protect the innocent patrons by asking the intoxicated individuals to leave. Modbury Triangle Shopping Centre, Party Limited v. Ansell, applied that mere intoxication does not give rise to a duty for the owner to remove an individual in order to protect other patrons. If we consider the High Court decision in Deals Palace v. Mubarak, in which it was ruled that the taking of reasonable care and security measures would not have had an adverse effect on the unpredictability of the criminal behaviour and the outcome, the defendant should not be held liable for the harm. The same principle applies in this case, as no action or inaction of the defendant could have prevented the harm caused which affected the plaintiff. The damage caused to the plaintiff is far too remote from the duty of care owed by that of the defendant. The unpredictability of the criminal's response ultimately means prescribing an occupier of a premises a duty to take extra precautions is unrealistic and outside of the duty of care owed from defendant to plaintiff. To prove factual causation, as required by Section 5D of the CLA, it is not sufficient to consider that a plaintiff's injuries might have not transpired if more security measures were in place. The plaintiff would have to prove that it would be more probable that they wouldn't have occurred, which does not match the facts of this case. Those are the defendant's submissions, Your Honour, and unless I can further assist the court, the defence rests.